Y'all ready to go on record?
Sure.
Yes, sir.
All right, well then let's officially get started. So, all right, so this is the afternoon civil non-jury calendar. This is the case the court calls 16 SV 89, Maynard versus McGee and Snap. This is, I asked you all to come in today for a couple of odds and ends for me to sort out, plus things that y'all had that we needed to address. My main items that I have on my list, just to make sure we're all on the same page, are to deal with the phone question of how do we get here and what do we do next and what is it actually? And then I told the defense that we would talk about, defense Snap, that we would talk about the deposition of their CEO and kind of figure out, see if we can get something set and get those gears turned properly to make certain that y'all have time to get ready and y'all have the knowledge, y'all being the plaintiff have time to get ready and the defense have knowledge to be able to prepare their client for the deposition. So those are the two main items on my end. From the plaintiff's perspective, are there any other housekeeping matters that y'all were anticipating? I mean, stuff can come up, of course, but.
We are having some difficulty scheduling an additional deposition, 30B6.
Okay, so we'll talk that through. Even if we don't come to a conclusion, we'll at least open up some lines on that. All right, let me make a note of that. Okay, what do y'all have? Do you have anything, Ms. Kyle?
The response to the phone. I'm just here on the phone issue, Your Honor.
Okay, that was all I had for you on my
Yes, sir.
list, so, okay.
That's all.
So
And I
you're,
do have, Ms. McGee is here per your request as well.
okay, which one's, okay, hello, Ms. McGee, welcome.
Hello.
All right, so obviously we'll deal with that first since you're in the first chair, and then if y'all want to swap, that's fine, or we can just, there's no jury presence, so if y'all want to keep your seats, that's fine too. And then what, Mr. Bohr, Mr. Masterson, what, any housekeeping that y'all have that I need to factor into the schedule?
I don't think so.
Okay. Okay, so, help me understand the procedural status of the phone question, because y'all, the plaintiff filed, y'all, I need to stop pointing and saying y'all, because the transcript will not look good. The plaintiff filed the motion, but y'all had, the defense had indicated y'all may, like.
Snap filed a joinder.
Okay, that's what I thought. I just want to make sure of that. So, but it's y'all's initial moving, so if y'all want to get started,
Video?
yes.
Yeah.
Apple. All right, let me click that over. Give me a second. That should be coming up. Will you just unplug it and plug it back in? It'll chirp at me. I never did hear the chirp, and it's not telling me you're there. We redid it since y'all were here last. I don't know if you noticed that. So they had this monitor. We can do this part off record. We do this monitor. We had this little monitor over here, and we took it out so that everybody, because we have a lot of people that sit up here, and they have this really big monitor now that can see up there instead of the little monitors. Instead of all of us looking at little monitors, we all look at the big one. And then they changed how I'm supposed to push this stuff up. It just says share. That's correct. Are both of the lights on there blue?
Yes.
Did they ever replace this HDMI cord?
They determined it was that one that was broken. But it should come right up. Give me just a second. We're pretty adaptable here.
Yeah, let me jiggle it around. HDMI ports are so, you can take this sometimes.
and the necessity for the phones isn't needed. So he just got retained personally or hadn't been disclosed. I literally, Your Honor, did not have time to give an affidavit. If y'all want to continue so they can discuss his portion, do a deposition or anything like that, I'm happy to do that as well, Your Honor.
Thank you. What's your proposed solution, Travis?
My proposed solution is just as if he had submitted an affidavit 2 hours before the hearing, that it would not be considered by the court would not receive the contents, and I would say the court does not receive his testimony today.
Okay.
And a side issue, not irrelevant, but we note that SNAP and the plaintiff had to split the cost of the forensic exam. That was $1,500, and Ms. McGee advised that she was unable to contribute, so SNAP and we paid that by agreement. It seems curious, to say the very least, that she now has the resources to hire an expert at the last minute to appear and testify.
Okay.
And I can address that as well, Your Honor, if you
Sure.
need me. That's addressed with, thankfully, with the judges and Honor's help when he submitted the order towards Crystal McGee's participation. That order was transferred to the insolvency pool, and I explained to them the importance of participating fully and providing a complete defense to Ms. McGee. The insolvency pool now understands their role in complete defense and will be participating going forward in cost, and as we're instructed by the judge to do as a party to fully participate. And that is why initially we were told we could not share in cost.
Okay.
And that has also been kind of the back. And then the other delay is John Minor, who the parties have known through different discovery and tools of the different cases, knew of him as an expert, but he was unavailable and could not get the information the judge needs for today by today.
Okay. All right, well, let's just let him sit over there for a little bit. I understand the issue and the concern. And what do you anticipate his testimony will be, just so that we can have that on the record and kind of clear about where we're at and what we're maybe talking about doing?
Yes, sir. Your Honor, I anticipate his testimony will be that although the phones are gone, potentially all gone, that they're not necessary because we have the data from the track phone itself and we have the Snapchat data itself, and therefore the phones are not necessary.
That you're saying that the data that's already been pulled from the first phone we have, plus the data that's been provided by Snap, is sufficient?
Not necessarily the data from the phone, Your Honor, it's the data that was pulled from the non-party to actual track phone, the track phone data.
Oh, yes.
The track phone data from years ago, and then the data from the 2000, I believe it was in 2016, when Snap did their motion with all the mega data, that the actual phones themselves and the data from the phones is not necessary because that same data can be obtained in all these ways.
All right. All right, let's just let him sit there for a little bit. I'll think about that. Like I said, I want to hear from y'all first over the whole picture. He can sit there a little bit. He'll be okay.
He's fine.
And
Awesome.
then, let's see, is there anything else we could go ahead and address? Do y'all have, let me look at my list here. We could, do y'all have a PowerPoint or any visual presentation on the Evan Spiegel question? Or do you have a PowerPoint on that one as well?
We don't.
I think I raised that up. I think I can talk about that, Your Honor, without a PowerPoint.
Can we swap, let's just swap the topics then.
Absolutely.
Everybody take a minute and take off your cell phone hat, and we're gonna pivot over to the CEO deposition question. And that'll give Liberty a couple minutes, and they can work over there while we're talking, so. Okay. All right, fill me in. And you're welcome to sit, stand, pull the mic on. I mean, I have no preference, and you all may move about as you see fit. Just don't get in each other's personal space.
I was primarily concerned, I know that this is being live streamed and Mr. Khan, I know the court, at least I hope the court can hear me.
I can hear you great.
Am I okay with the microphone or however?
Yes, because that microphone up there is actually the one straight above in the middle, above the lectern, is the actual feeding out microphone, and it's made for a ginormous arena area. So it's very good at what it does.
Okay, understood. I wasn't clear on all that, so thank you for that clarification. I don't think this is hard. As I said in my email, I apologize that we even had to bring it to the court's attention. I've never had anybody file a motion to compel something to happen and then the court indicates their leaning or their decision, and then you try to schedule it with them and they refuse to do so. But wonders never cease, I suppose. I have reached out, not just, this is broader than just Mr. Spiegel's deposition, as Your Honor will require as it relates to the CEO of the company. And I hope this should be somewhat axiomatic. He's busy. He has other responsibilities other than responding to this lawsuit. Not to say that he's not taking it seriously, it just means he has other responsibilities. Beyond that, he has a paternity leave that's scheduled to start very shortly after the date that we offered. So we offered the date in hopes of getting it on his calendar. I went so far as to say, the response was, we can't decide that yet because we don't have rulings on the protective order and we want to take the corporate representatives first. I said, okay, well, can we just schedule this so I can put it on his calendar so we don't lose this opportunity? If something changes based on your Honor's rulings or whatever, then we'll be happy to, look at different dates, but they'll probably have to be after his paternity leave. That was not accepted. And as one might imagine, the folks at SNAP were anxious for me to get an answer to whether or not I needed to hold the CEO's time further for the litigation. And so I pushed and got no answer, and that's why we brought it to the court. Understanding all that, and with another week or two passing, and then they sent more recently a new 30B6 set of topics. I would note that we obviously haven't even made it through the first notice, and they're noticing more topics, and I don't really fully understand all that, but the long story short is I've told them at least 5 or 6 times, right? That if they just call me, we'll look at the calendar. I need to know who they want to take or which topics they still want to cover. I will set up the dates, and I ask them to do that now because, as Your Honor recalls, you've ordered us to pay for it, and travel does get more expensive the longer you wait. So I was just trying to get the things on the calendar, in May or June or July or whatever it is, and that's where we stand. So I heard Your Honor. I was sitting in a different chair, but I heard Your Honor last time. I've taken that to heart. We've worked on figuring out which witnesses are going to talk about which one of these topics, and getting them prepared to answer those questions. And I've offered I just want to get a week out in California or wherever these witnesses are, or 2 weeks or whatever it's going to take, get it scheduled. And then if they want to do that first, I don't even care about that, right? I'd given that date in June for Mr. Spiegel. If they feel like they need to take June and July or whatever it is to finish these corporate representative depositions, that's fine too. I just want to schedule them, get them on my calendar. I mean, I also have a case or two that I'm responsible for other than this one, so I can make time to make sure those witnesses are prepared and answer the questions. And that's all I want. I just want them to give me some dates for that. And then if that means we got to set Mr. Spiegel's deposition out, August, September, whatever it is, so be it. But my request remains that I'd like to be a little bit respectful of his calendar and get a date certain and have it on his calendar so it's held. If the circumstances change for some reason, like I said, I'm happy to work with them. Otherwise, I don't think this is controversial. I've honestly never had a conversation about deposition scheduling with the court that I can remember in my life. So that's the issue, Your Honor.
So tell me the paternity window where your client's unavailable.
Yeah, I'm not real clear on
Ballpark
that. Call it June 15 to however long a paternity leave is. I don't know what the California law is. He may not take. I don't have a date of it ending, and he probably doesn't either. Right? I think it's probably going to be in some way formed by whatever he's got to do in terms of his responsibilities. But I think they're roughly 3 months.
Yes.
Okay. But it may be it potentially is shorter than that, depending on obligations and responsibilities. I don't really know.
Okay. So potentially June, July, August, or at least some portion of each of those. So I'm looking at that September would be the first kind of almost guaranteed window back. Am I hearing from y'all's perspective?
I think so. Yes. I mean, right. Since we're doing corporate representatives, and in fairness, with the summer schedule the way it is of vacations, it'll probably take us May, June, and July to finish those depositions, is what I think. But I don't want to speak for them.
Sure. Okay. Anything else?
Not on that.
Right. All right. Let's pivot over then. All right. Tell me where, Mr. Adams, are you taking point on this?
Yeah, I'm glad to. Thank you, Bill.
All right. Fill me in, please.
Yeah, well, this started with Mr. Khan courteously offering us June 10 and saying, Mr. Spiegel has an availability on the 10th. Please let us know as soon as you can whether you are able to do the deposition on the 10th. So we responded that, well, we haven't received the court's order yet. We know SNAP has yet to file some motions regarding the 30B6 depositions and a motion for a protective order regarding Mr. Spiegel, and we're not in a position to commit. And shockingly enough, we understand Mr. Spiegel's position, and we're not going to say just hold this date open until May 30 when we know. So we just said, based on what we know at this time, we're not in a position to agree. Mr. Masterson seems to have taken the position that we need to take the 10th or say what else we want to do. Now, what we did is we sent an email this week after he had spoken to you, so maybe progress has been made. But we sent an email saying, here are all the depositions that we have in mind immediately. Here are the 30B6s we want to complete. Here is a deposition that we would like to take that is a new deposition. And that is, we said that's going to be a Zoom deposition, maybe 2, 3, 4 hours. And that is to just understand the terminology of the Blizzard, because the Blizzard data has a lot of stuff we've never seen. And so we just want to ask, what does this mean? What does that mean? When we see this, should we understand X, Y, and Z? It has nothing to do with the accounts. We're not asking about contentions or anything like that. So we just said we would like to do these in the following order. At least as I sit here today, that has not been agreed to. Mike reached out to Mr. Khan, and they had a cordial conversation about it, exchanged views. Mr. Khan was going to check with SNAP and just see if they're able to make someone available. But it's just a matter of lining up the depositions and picking dates, not knowing what the decision will be on the scope of the depositions, et cetera. We will note that the deposition regarding Mr. Spiegel is fairly narrow. The motion for a protective order regarding Mr. Spiegel is fairly narrow. But the motion regarding 30B6 depositions is pretty sweeping. And from our perspective, relitigates things that this court exhaustively addressed and ruled on before the first depositions started. So that's going to be, we're going to have to file a response. I don't know if the court's going to have a hearing. For us to try and say, how about we do it on X, Y, or Z dates is going to be challenging. But we said May is difficult for us, but if we can do this new 30B6 topic on these 5 dates, I think end of April, beginning of May, if we can do the 30B6 depositions in June potentially, and then when those are done, we take Mr. Spiegel's deposition. We're kind of proposing a framework like that, but as we sit here today, we have not solidified it. I don't know if Mr. Khan has. And Mike has some additional comments if the court is willing to allow us to do that.
Oh, sure, but so what I'm hearing you all say essentially the same thing with just different speeds.
Okay.
Am I missing something?
You are, Your Honor. SNAP has initially taken the position that they're not agreeing to make someone available to testify on these new 30B6 topics, which brings up your frequent repeating that the plaintiff gets to pick the topics. So as I understood Mr. Masterson's emails, SNAP doesn't think that we should be able to depose this person on what the data means from a definition perspective. They think that needs to get pushed into Ms. Hayakawa's technology deposition. And we explained, well, before we depose Hayakawa on tech related to this case, we'd like to understand what the documents and the terms mean. So we want to take an education 30B6 deposition the end of this month or the beginning of May. And Snap's initial position was no.
No, it wasn't. That's false.
Okay, I've said this at every hearing we've ever had, that I'm aware that Mr. Masterson and Mr. Neff will never go out for drinks after work. I'm okay with that. You all are both doing a great job zealously advocating for your clients. There's no scenario, in my opinion, that you two will ever agree on anything. I will sort this out. This is what I do. I know Mr. Masterson, but this is what I do. So just let him finish. And then I kind of have a halfway baked idea that's going to sort these things out. So I know you disagree, but let him finish.
It's not about disagreeing. He's misrepresenting things that are in writing to the court. I can't stand that. That's why I'm reacting.
I know that. And I get what you're saying. And I just breathe and know that I have a good handle of this case. I have breathed this case since before I took office. So I'm with us. I know where we're at. Go ahead.
Thank you, Judge. I appreciate your comments. There were multiple emails exchanged with Mr. Masterson that say what they say. And I did have a cordial conversation with Mr. Khan yesterday afternoon. And he asked me questions about why we wanted to do it. And he threw out the idea that, well, why isn't this subsumed within Hayakawa? And I explained why. So long story short, we have not gotten that deposition scheduled. We have not gotten agreement on anything. We have read Snap's motions, and we feel like we have to file a formal response. So that's not due until May 8th.
Okay. So Mr. Masterson, coming back to you then, as far as getting the 30B6 topics finished, let's just talk concrete moving forward. What is it that you all are looking for to get the 30B6 deposition? What is it you need to get this closed?
So in 9,999,999,000 times in Georgia, when a corporate representative is requested, the proposing or deposing party sends a notice, okay? And they say, we want to depose them on these topics. And then the defendant or the plaintiff, depending on who it is that's corporate representative is, identifies the person who's responsive to answer those questions. And then you go and you take a deposition. At that deposition, you might say, tell me about this terminology on Blizzard. Thanks for defining that for me. Now, let's talk about the specifics of the Blizzard spreadsheet here, okay? So what I want them to do is to take a corporate representative in the manner that Georgia law prescribes. What they did here is they did the first part of that. They gave us a notice of 38 topics, okay? Then after that, they said, well, we can't do the ones about the metadata because we don't have it yet. You'll recall it took a while for that to come out, okay? And so I said, fine, let's go ahead and get some things done. So they send out sort of random ordered topics of the 38 or whatever it is. And your Honor's familiar with that process, so I won't repeat it, okay? But they've had all of the data for 5 months now, okay? So there's nothing holding up doing this in the normal fashion now, which is go and they don't have to do it 1 through 38 in that order. That's not what I'm suggesting, but they send topics, we identify the witness, and they ask them questions, okay? In this instance, there hasn't been any refusal. The reason I reacted is because I have never told him, no, we will not schedule a 30B6 deposition. I went so far as to go to the court to say, I'm trying to schedule these and they won't give me dates. That's just false, that I've never said no. I said that we get to decide as the defendant who answers those questions, right? And that witness is the same witness, right? Miss Hayakawa, right? Krista Hayakawa, who they've known about forever and they've identified. And then all I said beyond that was, Mr. Neff, if you want to depose Ms. Hayakawa, she's going to be designated to these topics. You can take her deposition on all of those topics that you've identified for her, including the new topics. I'd just like for you to do that at once. And the reason for that is it's in California, and we have to fly out there, and this witness does it. The idea, I don't know what Education 30B6 is, okay? He's just making up things that don't exist under the Georgia Civil Practice Act. It's a 30B6 deposition. You go out there, you ask him questions. You don't get to ask him questions one day. I've never heard of this in my entire career. One day, like just sort of some general questions, and then call this corporate representative back in another day and ask him 7 hours of question. And then, well, I thought of some other topics, and you call him back in and you ask him 7 more hours of depositions. That's not how it works in Georgia. All I want, right? They can start with 1 and go to 38. They can go 38 to 1. They can go in some random order that they pick out of a hat, okay? And I'll have the witnesses, as you've suggested, sitting out there. I guess they can come in and out and do it. I just want them to do this in a set period of time and finish this process. And I will do my part, as Your Honor has instructed, to make sure the witnesses are prepared. And if they can answer the question, they answer the questions. But I don't want this piecemeal, and I don't want Ms. Hayakawa to have to be deposed once, and we got to go out there and take her deposition again, or go take her time 2 days. Just do it in 1 day. That's all I ask. That's what I want.
One pass.
Yes, Your Honor.
All right, so as far as what is the number of topics that the plaintiff still has outstanding for 30B6? Just the number.
Well, all of them, because based on the court's prior ruling. What we sent on, I think, earlier this week was, what, 8 topics?
Maybe, yeah, 7 or 8.
Right? 7 or 8 topics for a Zoom deposition so that we could ask questions about what does this column mean? What does this field mean? In significant detail. So that when we have an opportunity to depose Hayakawa about the allegations in this case, we know what they mean by whatever the term is. And SNAP is refusing to do that. Let us take that deposition now so that we're prepared to ask questions understanding what SNAP's terminology means. They want us to show up and do that cold, which doesn't strike me as organized or efficient. We offered to do it via Zoom. We don't have to travel out there twice. And we cannot get responsive dates from them.
Okay, so, and I agree with your statement that, yes, the topics are all out there, but in my mind, this round is going to be the round. Like, once we finish this, we're done as long as, when I read the transcripts from the depositions, I feel satisfied that the witnesses were properly prepped, which I'm very confident will happen this time. So the short answer is that the way I'm anticipating this going is that you all, I thought, were going to just send your topics over. They were going to sort the topics into the witnesses, and then y'all were going to go do it. So I did not anticipate this multi-phased deposition. Like, in my mind, that was not what I had in mind. That we would do smaller depositions and then bigger depositions later.
Well, if I could comment on that, just real brief, Judge. We initially proposed the first 38 in May of last year. Then we got documents at the end of this year. So what changed between May of 23 and April of 24 are these new documents.
Yes.
Right. And for us to review the documents is one thing, for us to process them is one thing, for us to really understand what the terminology is a complete third thing. So that is why we're proposing that we take a video depo to go over the documents, not asking questions related to the first 38 topics, but just allowing us to get familiar with what SNAP's terminology means so that when we get into the 38, we only have to do it once.
I just don't understand how that can't be answered ahead of time in a more informal manner. I guess that's what I'm struggling with, but I know y'all don't talk. I get that. Like, I'm okay with that. I mean, you're not the first attorneys that I've had to, referee. But I'm just saying, Mr. Adams and Mr. Bohr can generally tend to communicate pretty well. I just don't understand why we have to have a formal deposition to get, what is essentially a dictionary definition of some terms. Help me with that.
Judge, this is Reuben Kahn. If I could just, when I spoke with Mr. Neff yesterday, and I thought our conversation was cordial, I think it was professional. I suggested that we could provide definitional terms to them in some sort of informal way, and but that was Mr. Neff didn't, as far as I understand, accept that suggestion.
Okay. Well, I have my decision, which is the answer is no, no, like no. You need to send all of your topics to the defense. The defense is going to take all of your topics and divvy them out among the people they're going to do. They've already know very clearly that I'm out of patience with people that can't answer their questions, and they're going to do a really good job making certain that your questions, all of them, are divided out among the people that can answer them. As I said, even if it's that they're all sitting out in the hallway and you got to ask each person one question and they are the subject matter expert on that one question, and you got 100 people in the hallway. You're going to get those answers. But I cannot justify a deposition on what could very easily, in a more amicable situation between attorneys, be something that could be very easily sorted out with a couple of emails back and forth of what does that mean and what does this mean. So the short answer is that you have every right to have those answers ahead of time, and you're going to get them, but we're not going to do them by deposition. That is a too formal, too cumbersome, too slow process. I expect y'all to work together, swap the definitions, and get that information to them so that they can know. But we are moving forward with all of the 30B6 topics 100%, and we're going to get this done. Yes.
Can I throw a suggestion out that the responses be verified and that we have the opportunity to ask follow-up questions?
You mean as far as no, I want this to be no, I'm telling you, do this informally before I deal with this formally.
Okay.
Again, Mr. Bohr and Mr. Adams are usually able to communicate. So like, I mean, like even sitting here, Mr. Masterson and Mr. Neff are as far apart as they can be, which is fine with me. Mr. Bohr and Mr. Adams are a little bit closer together, which is normally the way we do this. So I would like to nominate Mr. Bohr and Mr. Adams and Mr. Kahn to communicate and get this information swapped back and forth. If I have to do this more formally, I will, but that is not my intention. And frankly, I'm going to tell you, I'm going to be very slow to do it. If I have to really dig in, then frankly, what I'm going to do is, well, I'm not going to get that far. Y'all get this sorted out. I do not want to step into this in the formal way. So,
If I, Judge, if I could test the patience of the court just for a few seconds. If you would kind of hold your ruling in advance. I once had a judge said to me, I'm probably going to deny this motion, but you can argue it. And he ended up ruling in my favor. But allow us to send you this notice so you can see what it is. It's not a list of terms that we want to define. It is, I don't know if you've seen any of the Blizzard documents.
I've seen about this much.
Okay, these are spreadsheets with,
Yes.
say, 80 rows, each one with a column heading. And so we sent a notice to forestall the issues that brought us before you last time. We have a topic and we say, this seeks to understand, and we will include questions like such and such. So Paul is willing to talk to me, I'm willing to talk to Paul, but Paul wouldn't know the answers to these questions. These are highly specific questions, like what does data category snap times sec mean? This is what we put as an exemplar. And if a numerical entry such as 10 appears within this column, what does that mean? And so for us to do this in interrogatories or informal conversation, even among the best of friends, I don't think would get us the answers we need. That's why I was proposing a deposition that could be a low-level engineer, so to speak, we're not going to say, hey, we have an allegation that just say, hey, if I see this in a column, what does that mean? If I see this, what does that mean? And he might say something or she might say something, and I say, oh, okay. And when I talk to Ms. Hayakawa, and she says, our contention is this, I'm like, well, our understanding that this term means such and such, and how come I see these entries? That's all I'm asking. If the court looks at it, I think that may become more clear than it has from our conversation.
Well, I understand it, but I also understand that I'm putting more pressure on Mr. Bohr than I'm on you, because he's got to talk to the technicians at Snap who understand this stuff in a way that as we all are well aware, technicians, i.e. my twin brother is one of those people. And every now and then I have to say, look, I just need you to stop talking because I don't understand a word that's coming out of your mouth. He works for Home Depot and he does something with their computery stuff. But my point is that, Mr. Bohr is going to have to take your questions, take them to them, translate them back into a 5th grade level so that we can all understand it, and then give them back to you. So like the real burden here is on them to find those answers. So I get what you're saying, but like I would much rather they figure this out and get you this information, and then if I have to get more formal into it, I will. But does that make sense, Mr. Bohr?
I think it does, Your Honor.
Yeah, because you're going to have to reach out to your client and go, I assume you're not a Blizzard data expert.
No, I'm not.
Okay, so you're going to have to contact your Blizzard data expert there, or Mr. Khan is, and say, what are these terms and what do they mean? And then get those back. Now, if you don't like those answers, well, then we'll figure that out. But
that when they get to the deposition, they can verify with the witness that's designated on that topic. They can ask them under oath whether those are true or false.
so, yes, that's true. But I'm also saying, more importantly, I want them to be able to understand the terms before we get there, so that they can have better questions and therefore get better answers. So, I get what you're saying, Mr. Adams, and I'm not disagreeing with you at all. I'm just saying, let's do this first. Let's do this first. I do not want to do a formal deposition to set up formal depositions to then schedule formal depositions. That scares me. That has not worked for me in the past. So I'm sorry. That has not worked for me in the past, and I don't think it'll work for me here either. One of the things I do want to talk about though, coming back, is that I do like the idea of y'all sending over all of your topics, letting them sort them, tag them, assign them, get this done this summer, and then you can depose, you finish those, and then depose Spiegel when he comes back from paternity leave, because y'all want to finish those 30B6s before you talk to him, and I would too, and I understand that, and I'm okay with that. So I will tell y'all, please talk to your client, figure out something in, I don't know, September, October. I mean, he's coming, so we're looking at June, July, and August for paternity, and then so I'm looking at September. I'm just counting months. It's no secret here. So I'm looking at September or so to get that scheduled. I would like to go ahead and get that scheduled. I would like for that to be on the books, because that provides a deadline for all of us to get everything done we need to get done, to get in the room with him and make certain that y'all have a quality deposition that you deserve to have, and you all have the time you need. That's what I'm saying. October is like, once he comes back, you may need to work with him a little bit to get him ready. And so y'all need to get him ready, and y'all need to be ready to get the best deposition you can get. So, but I don't want it later than October. So I want to get this thing done, and I want to make certain that we have everything both sides need done before we get into that room. So, and again, I think coming back to the 30B6, I think Mr. Bohr is kind of stuck with the heavier lift here, because he's got to understand it, translate it, and pass it back to you. And obviously, if they want to put somebody on the phone with you, that's fine. We've all done that, where you talk to somebody informally on a phone without a recording and ask them a bunch of questions. We do that. We've done that here with conference calls, where we're just like, hey, what is this and what is that? And Miss Kathy does a wonderful job, but we don't let her come to those, because it's us speaking more frankly. And those have been very productive for us. And I don't see why that model can't be used to get some things unstuck, especially if our 2-point people are Mr. Bohr and Mr. Adams. So, all right, Mr. Adams, I understand your point, but does that at least help you understand that I hear what you're saying, and I'm not shutting you out. I'm just saying, let's try this first.
I understand.
Okay.
Can we have an aspirational deadline from the court on setting aside some dates to go and take these depositions of the corporate representatives in June? You know how summer is. I just want to get them on the calendar. I'm not trying to. I ain't got an agenda other than I want to know when they are, so I can figure out my schedule to try to fly out there and prep these folks, and then also go to their depositions. And that's the only reason I asked for scheduling.
Yes, and I would like those scheduled, not ASAP, but you know what I mean. But I want a date
Scheduling
picked.
to
I want a
occur.
date picked ASAP.
Yeah.
The date doesn't need to be next month. It needs to just be as soon as everybody says, hey, I could get ready for this. I could get my people ready for this in this amount of time. But I would like the dates selected like yesterday. I want everybody to look at everybody and know, because obviously Miss Gower is sitting there very quietly, but like she's got to make plans too for travel on this. And so, I mean, that we need to get some dates set in pen on calendar for Spiegel and for the 30B6s. And so I would, I'll go ahead and say I would like those finalized by the end of the month. Today's the 20th. That gives everybody a good 10 days to swap a lot of emails and figure out what days work best. Look at your own leaves. Don't cancel your family plans because of this. We will figure it out. That always hurts my soul when I find out later that somebody canceled their family trip to the beach for a deposition, because none of us are going to retire from home to go to work. So, but at the same time, we need to get these things finalized and we need to get them moving forward. So,
If we judge as we prepare to finalize dates by the end of the month, let's say we file our response on May 8th as it's due, how much time should we budget for the court to rule?
Will we have a hearing?
You talking about for the protective order?
Yes.
Yeah.
I have no intention of having a hearing on that.
That's what you said
So
before.
I said last time I wasn't gonna have a hearing on that.
Okay.
So,
Okay.
so my plan on that one was to get that back to y'all by the end of the month. So May 8th was to get that back to you by the end of that month, end of May.
End
So,
of May. Okay.
so that was my intention on that. And no, I have no intention of having a hearing.
And that June, July, that'll give us June, July, and August to
And that
schedule
was my
this.
thought. So,
Okay.
Understood.
okay.
So by the end of the month, we'll try to set aside, well, we won't try, we will set dates in pen, understanding something might come up. I'm not, as I said before, not trying to be difficult but we'll get those set and then we'll look for a date in September, October time period for Mr. Spiegel.
Okay.
Okay.
All right. I think that gets us organized, and I think everyone is the appropriate amount of unhappy with what I'm doing. So, anything else, Mr.
Yeah,
Adams?
just regarding deadlines, the informal process of exchanging information with Paul, with Mr. Boer. Do you have a deadline that you would give us for that or a time frame?
I started to, and then the reason I didn't was because as technical as this case is both very simple and very complex at the same time. I mean, as we all know, on one side, it's a fairly sad but factually straightforward auto accident case. On the other hand, it's a very complicated technical case. And the reason why I didn't say I'm setting the deadlines of this is because I think Mr. Boer's answers are very likely to create additional questions, which are going to be legitimate, in my opinion, because it's the way I normally do it. Somebody sends me back new information, I digest it a couple days and go, okay, all right, I think I understand 1, 2, and 5, but that 3 and 4, I don't get that. Can I get a little bit more information on that? So no, I don't want to put a deadline on that other than I expect full speed ahead but everybody's going to need a couple days once you get it to process it and get back. So, I mean, I'm very comfortable with technology, and this case is very difficult for me to keep my brain wrapped around it. And I helped create all of this that you see in front of you. And your case still makes my mind almost melt every time I dig in. So, so no deadlines on that. Just move quickly, get them their questions over, get them back. Because I think that's going to be a continual swapping of information and clarifying, and it's going to be a funnel. You're going to swap a lot of information, then you're going to swap a little bit less, and then a little bit less till you get everything answered.
Done.
So, but no, this way the SNAP team doesn't have to be preparing for formal depositions. They can just do it informally. And I'm trying to get them the information while making it a little bit easier on SNAP. So that's my balancing point. Okay. Well, what else? Anything else on these depositions and getting this finished? I would like these finished by the fall. That's my goal, is to get all of this set of depositions finished by the fall. Other than these depositions, do y'all have, I guess, any other depositions that are outstanding that we haven't discussed?
Yeah,
Yes.
yes, I think Mr. Adams and I were able to successfully communicate and set Mrs. Maynard's deposition
Okay.
with very little acrimony, actually. And then there might be a law enforcement that shouldn't be hard to schedule by an agreement, and then potentially a medical provider or two. That's what I can think of.
So
off
back
the
to
top
kind
my
of our
head.
standard depositions.
An expert. An
experts.
expert.
Oh, I was talking about fact witness.
Okay.
I did.
It was a
that's what I-
fact witness question, but my next question was going to be, and what about the experts?
Yeah,
We will have experts.
So I
then
figured y'all-
experts, right?
Okay. All right, that was just a casual question that I just want to make certain that what y'all just described and what I expected were the same thing. So we're on the same page. Okay, anything else on the depositions, before we pivot to the next items?
Not from us.
Okay, all right, let's go off for a record. Everybody set the restroom real quick and then we'll jump back into the next round. So. just put on record that the court's having some, the court did some stuff with our technology yesterday to update it, but it's given us fits today. We figured out a workaround, so we're just gonna get going on it. I appreciate y'all's patience as we've gotten our technology moving. You're all set up for your PowerPoint? Y'all ready? Y'all ready?
Yes, sir.
Yes, Your Honor.
Okay. All right, then, Mr. Adams, Mr. Neff, floor is yours.
Thank you, Judge. So this is on plaintiff's motion for spoliation sanctions against the defendant, Crystal McGee. This is a lot shorter than last time, so just a few points we wanted to make. It is undisputed that McGee admits she received the spoliation letter about 3 weeks after the crash. Fast forward to April 25, 2023. Her counsel provides the phone to our forensic expert, Jim Persinger, who is on the line with us now. And Jim, I'll have some questions at the end. Mr. Persinger, the court is painfully aware of the process that it took. The phone wouldn't start. We had to get an agreement to send it to Teal Tech, Snap, and the plaintiffs split the cost of getting a chip-off procedure at Teal Tech. And then they sent that to Mr. Persinger, who used Cellbrite to generate a report of the entire contents of the phone. This was a 590-page report that revealed only one user on this phone. And I'm showing the court just an excerpt. The data is divided into categories, and one of them is users. And this is the only user found on the phone. We did not find any reference to Crystal McGee in any of the 590 pages. So in her deposition on February 26, Ms. McGee testified that she continued using the phone after receiving the spoliation letter until June of 2016. That's about 8 months, at which time she provided it to her lawyers. She testified that the phone she gave her lawyers was her phone, and the same phone that she had used during the crash, or that she had on her person during the crash. And finally, that no one but her lawyers had access to the phone before or after the crash. So after we filed our motion, the pending motion, the story changed, and you received an affidavit, and I'm highlighting a few paragraphs of that. Paragraph 5. Because the screen to my cell phone was broken, I was using a cell phone that belonged to my sister, Holly McGee, at the time of the incident. This was in the affidavit filed last week, I think. But in her deposition, Ms. McGee testified it was her phone, and that she did not get it from her sister. And under questioning by Mr. Masterson, she responded, she was asked, let me ask you, what phone did you have? Do you know what kind of phone it was? And she said it was a flip phone through Straight Talk that I got from Walmart. She was further questioned. Identify every phone you owned or used on September 10, 2015 and September 11, 2015, stating the make and model, the phone numbers, and the person to whom the phone belonged. She responds, I did not have more than one phone. It was my only phone. Okay, did you have any other kind of phone on September 10 or 11? No. Who owns the phone? I did. So in our reading, that directly contradicts paragraph 5 of her recently filed affidavit. So let's move to paragraph 6. After the accident, I was keeping my cell phone in a secure location in my bedroom as requested by plaintiffs in their September 29, 2015 letter. But at her deposition, she testified that she continued using the phone for 8 months after receiving the spoliation letter. She was asked by Mr. Masterson, did you continue using your phone after receiving that letter? Yeah. Did you continue to use your phone in September, October, November, December, January, February, and March after receiving that letter? Yes. All right. Did you use the same phone that you had at the accident in April, May, and June of 2016? I did. In our perspective, this is inconsistent with keeping the phone locked in a secure location in her bedroom. Paragraph 7. After learning that the plaintiffs are saying the information from my cell phone did not show my name or usage, I discovered that my sister Holly may have switched the SIM card from the phone I was using and put it into another phone without my knowledge or consent. I have underlined may have because that's what we have from the affidavit. She may have this might be the case. We don't have a definitive statement. But in her deposition, she had an opportunity to talk about the SIM card. And she was asked, all right, did you change out the SIM card or make any modifications to the structure of it? No. And I have it listed and in clarity to the court and transparency to the court. The rest of that, she talks about how she paid the bill. I don't want to appear that I'm concealing anything. She later says, I never deleted anything. Did anybody else? No, nobody had access to my phone. Further testimony. Okay, did anyone else use your phone? No. The phone you gave to Ann Gower, nobody ever used that phone. No one ever used that phone? No. Did any of your sisters have access to that phone? No, they had their own phone. So again, in our perspective, this is inconsistent with her deposition testimony that her sister may have switched out the SIM card. Oh, and finally, we had served requests on her that were then asked in her deposition. Did anyone have possession of your phone for more than 30 minutes during the period of time from the accident to when you gave it to Ms. Gower? And the answer was no. And we framed it that way, you know, I'm sure you might hand the phone to a friend to look at a picture or something, and we really wanted to get at, did anyone have possession temporarily or for any period of time of the phone? And the answer again was no. But Judge, these contradictions aren't the worst problem with her latest story. We have 4 questions about SIM cards, and I would like to direct them to Mr. Persinger, if the court will permit me, and if Mr. Persinger is ready. I don't see him on the monitor, but I'm sure he's there.
He's up at the top, second floor.
Right.
Oh, I'm sorry.
I was using camera, there we go. And he is muted. Jim, if you would unmute.
Okay.
Thank you, Jim. Jim, first of all, could you please briefly introduce yourself to the court?
Jim Persinger, CEO of PM Investigations, a business I've owned since really 2000, incorporated in 2001.
That's not going to make a great transcript. Is there any way you can clear up that audio?
Your audio
He's
is
got
not
some-
outstanding.
Got a little bit of just a little bit of background noise or feedback.
Does he need to be sworn in, Your Honor?
Dave, better?
Yes.
Are we able to hear me okay?
Kathy.
I'm good to go. It's,
Okay.
there was
You
like
swear,
an
ma'am.
echo.
Okay. Well, Jim, we have a question from Ms. Gower about swearing you in. Why don't I go ahead and do that?
I'm sorry, say that again, please.
Yes, we have a question from Ms. Gower about swearing you in. Out of an abundance of caution, why don't I go ahead and do that?
Okay, I can't see anybody.
Okay,
You can't see?
he can't see
My
it.
camera says it's active.
I'm not stopping any of that on my end.
We can see you, certainly. Well, can you see this? Well, we can probably go forward with you just hearing audio. You'll be talking to a blank screen, but we can hear and see you.
Okay,
Okay. Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Persinger, how long have you worked in the field of forensic phone examinations, if that's a fair description of what you do?
A little over 23 years.
Okay. And Judge, I won't belabor it. You have it in his affidavit. I'll keep it moving. Mr. Persinger, the first question I want to ask you is, what is on a SIM card?
So SIM, basically a little smaller than a postage stamp, fits inside of the cell phone that contains the individual cell phone number.
Okay. Does it contain anything other than the phone number?
It'll have some miscellaneous information that allows the cell phone to talk to a specific cell phone provider, commonly called like MCC codes. And that's basically it, just from the days of when a cell phone was locked, meaning that it had to be with a specific network versus today, which is more so of a phone that is unlocked that can talk to other networks. The SIM contain that information to keep a person from cloning the SIM and using it on multiple cell phones.
Okay, so to recap, it sounds like it has something I colloquially refer to as a serial number, I guess, and the just data that allows it to talk to a network.
Yeah, now what's called the IEMI or the NCC, that varies from SIM to SIM. It has nothing to really do with the individual's data that they create, but it will contain, in every case, the cell phone number.
Okay, so the 590 pages recovered by Cellbrite, is that data stored on a SIM card?
It is not.
Okay. Does a swapped SIM card explain how there's no trace of Crystal McGee on the phone that was imaged?
Taking the SIM and exchanging it, putting it into another phone would not have any impact on the data with the phone itself.
What could a person stand to gain by secretly swapping out another person's SIM card?
Well, the only thing I can think of is obviously it would just present a different phone number. Have, again, zero impact on the data.
So I am trying to, we have an allegation that a family member may have gone in and switched a SIM card. And based on your education, training, and experience, can you think of a reason why a person would slip into someone's room and switch out a SIM card?
The only thing, again, I could think of would be that individual was unaware that the data did not reside on the SIM, that they believed it was sitting on the SIM. But that's the only thing I can come up with.
Okay. And my last question at this moment is, if someone took the SIM card out of your cell phone, a cell phone that you use regularly, would you notice?
Only if you were making a phone call, because then the caller ID on the other individual would show the different phone number.
Okay, so let's say I have an iPhone now, but if I had a phone 10 years ago and someone just took the SIM, I'm not talking about swapping it, just took the SIM card out, would I notice that? Would I be able to make calls?
You'd be able to do Wi-Fi calls, but you wouldn't be able to do what's typical cell phone calls.
Got it. Okay, thank you. So I don't know if the court has questions or any of the other parties do, but that's all I have at this time. We filed the motion, it was in detail, and I just wanted to address what came in the response and with the affidavit.
Okay.
That's all I have at this time. I'll take my seat.
Ms. Cowell?
Yes, sir.
So just obviously be slow. Mr. Persinger, the audio is not awesome, so make certain, not awesome as being very nice. Be very nice and slow and loud. Nice and slow and loud, okay?
Yes, sir.
All right, go ahead.
I don't have anything.
Oh, you don't have any questions?
No,
Yep.
not yet from Mr. Persinger.
All right, do you have any questions?
Not right now, no.
Okay. Mr. Persinger, you can mute yourself. Just sit tight, okay?
Is that? I think Mr. Coker will be able to help address and may even help go a little further. So, and Crystal is,
And their objection is outstanding. I haven't ruled on it
Okay.
yet, so let's
and it's,
just keep moving till we get to that moment.
okay, and of course, my phone not. I don't want to play my phone. It's response. Okay. So, Your Honor, we are here today on the motion for sanctions. The phone that was given, I'm not here to hide the truth of anything. The phone that was given to them was the phone that was in my possession. It is the phone Crystal is here today that she truly believed was the phone she was using at the time. It's been however many years since this accident occurred in 2015. We're here almost 7, 8, 9 years later. She's here to testify she didn't intentionally. The reason we asked for additional time was because I truthfully didn't know that the SIM card didn't contain the data until just now. Didn't know that myself, Your Honor. I'm not technology at all. Therefore, with my basic understanding of phones, we learned after the deposition that Crystal's father kept phones. So based on that knowledge, we had Crystal immediately bring us 4 phones due to some issues with insolvency pool and timeline. We had to get approval, get an expert. We got an expert. The first one, John Miner, who was used previously, who in the, I believe he was in the defamation portion, was unable to do it. I had to go to other resources. I got to know the name, Stephen Coker. We drove the phones over there or couried them over there this week. He got me the information this morning. He is under the impression, unfortunately, that the 4 phones we gave still are not the right phone. He needs more time to look and see to make sure there's no other data, but we stopped it. We gave the 4 phones, and my instruction was no destructive testing. And as soon as you get an inkling of knowledge, stop before we can get instructions from you, Your Honor, on what we need to do with those 4 phones. However, take that aside, I don't believe it's necessary for the phones to be needed, to be looked at, because you've got the track phone data and obviously all the Snapchat data. And the track phone data alone that's been here since 2017 shows that she wasn't on the phone for around an entire hour to maybe an hour and a half around the time of this collision. So we have that. That's why Mr. Coker's still here, to say that he can look at that data and tell you she wasn't on the phone. We've got the Snapchat mega data. I think it's called Megadata, I believe is what it's called. And we've got the Snapchat affidavit of Bong Lee that was in the initial pleadings that I'm not going, very, very beginning in their very initial pleadings, that says there's data that she wasn't on the phone. Your Honor, and you've got all that. I'm not going to rehash it. And the law is clear that I don't believe any sanctions really should be taken against Crystal at this time, especially striking the answer or saying that she was on the phone, because there's no prejudice to them. The data is there. Just because we don't have the phone, the data is still available. And Crystal is here today to testify, answer any questions Your Honor would like to ask of her directly. And I believe if you want to talk to her yourself and ask her, you'll see she has not intentionally done anything to destroy this phone. She put it in her bedside drawer, she believed, and then if her sister took it or whatever, she has not done it intentionally to destroy the phone. All she wants is closure and a resolution of this case. She's served her time. She's done what she needed to do. She is trying her best as a young woman to cooperate with the judge's orders, everybody's orders, but she's early 20s. She's got a 7-year-old child now and another child. She's doing the best she can, Your Honor. She's not intentionally destroyed anything. The law is clear unless it's intentional or in bad faith or prejudice the parties. That's when sanctions need to be taken. I think from all the, you've said you're well-versed in this case. You've got the information. There's so much data out there between Snapchat, track phone, and even I believe there's some Verizon that there's proof she wasn't on the phone and there's no prejudice. And this is just one little factor. And I don't believe the 4 phones are the correct one that he's got, but we can continue to keep looking and doing however Persinger suggested his stuff too. We're here to do whatever the court would like, and we're not intentionally doing anything. And if you would like to speak to her today, she's here.
Ms. Gower, I mean, you've been here before I was, so.
Yes, and I had the phone she gave me was in my possession under lock and key for however many years. Yes, sir.
And Judge Essery filled me in on all of the things that went along with that before he transitioned out. And, it was one of the things that we spent the most time talking about as he was bringing me up to speed before we then pivoted to the jurisdictional questions, which are not on the table today. But as you're well aware, that phone has been the subject of, countless hours and countless dollars and countless just emotional human effort in trying to figure out how to test it, what to do with it, how to get it out of here, how to get the information out of it. And I have to tell you, when I found out that there was no information of hers on that phone, I had a meltdown in my office.
Your Honor, I'm with you as well.
Because I thought we just wasted 8 years of our life trying to figure out the right way to get information, or frankly, to get blood out of a turnip, or I don't know, whatever phrase you want to use, like if I were to order her to pay back the time it took and the hours of each of these attorneys, plus the experts, plus the costs, plus 8 years worth of it, it's probably more than she would make over a couple of years. I just am so upset that this is where we're at after all of these years. Because I know you're saying it's not important, and I understand why. And I do understand that there are other sources of data that can help paint this picture. But as you're well aware, one of the crucial issues in this case that they will never agree on is what was she doing with that phone at the exact moment of the accident. And Neff and his team says she was using it for Snapchat. Masterson and his team says that she was not, and the phone was going to be the answer, and it never did line up. And I've been saying all along, we're missing, something's wrong here. These things the stuff doesn't line up. And now I know why. It's because the thing we're using is not the right measurement. So it's not your fault. Obviously, there's no allegations here that your office did anything wrong. Your office simply took into custody something, protected it, and then turned it over. But I'm just saying, I'm so upset. I thought about ordering her to pay for everybody's time and effort in this. And then I realized that would be probably over $100,000. Easy. Between the experts and the attorneys, of how much time was wasted, just wasted doing this. So I'm just communicating clearly how incredibly upset I am. And no, I don't want to hear from your client, but if anybody else wants to call her, she's here and she's fair game, but I don't want to hear from her. So I'm not calling her as a court's witness. Let me do it that way. If anybody else wants to call her, witness seat's open, microphone's live, you're good to go, but I'm not calling her as a court's witness. If you want to call her, I'd love to hear whatever you want to ask her, but I'm not going to lead the charge on that. So she's not my witness to call. So that's it. Sorry, I've just been waiting to say that for a long time. All right, anything else?
No, Your Honor, I believe her affidavit speaks to itself. I can happily put her on the stand to testify. Do you have any questions of her? Y'all, do you have any questions of her?
Okay.
Then I think her effort of being here, Your Honor, is, I don't want to put her in a position. I think her presence being here shows she cares. And
Well,
she,
my intention of ordering her to be here was that she could be here and witness this moment as
Right.
so that she could truly understand how much went wrong because either she A, intentionally didn't do it or intentionally swapped them, or B, didn't do what she was legally required to do by keeping her phone in a safe location after the accident and making certain that the phone we used is the correct one. So, that's why I wanted her here, was so she could watch this hearing and understand the severity of this moment and the importance of that phone to this case, because both sides now have to rethink how we're going to do it, how they're going to do everything.
Correct, Your
Without
Honor.
that phone. So,
And I understand that, Your Honor. And in all honesty, I believe it was just as much as a shock to her, definitely myself
sure.
and you. So, but I would just like to point out that, as you've said, there are other avenues, other methods. And for our aspect, this is just a simple, for her, automobile liability collision that we believe she has a valid defense that we would like to maintain as well.
Well, and you've heard me say this is both a very straightforward case and a very complicated case, because it's a very serious case, but it's also an auto accident that we handle dozens and dozens and dozens of every year. So I understand what you're saying when you're saying
And
that.
Your Honor, and then I am solely an auto lawyer. I don't do the technology. I learned just as you may have learned about the SIM cards and the usage today, and that's why we have the Coker and the 4 other phones that I will get with the parties afterwards, and we will come up with a plan on if we want to do anything more or less with that information.
Okay, thank you. All right, Mr. Masters, or
I guess I may be going out of order. I guess what I would say, right, is we've joined this because Snap has never had any possession and control of this phone. Certainly didn't direct anybody to do anything with it, nor is there any allegation even from Mr. Neff of that. I don't know. What I do know is that there was an accident in September of 2015. I know that there was a preservation letter sent by Todd Hensington, who represents the Maynards, pretty shortly after. And then there was later on, I think about 8 months after the police investigation opens up, and there's some charges that are brought, which were referenced. We don't need to go through that in detail. But in June of 2017, I read this affidavit. I wasn't involved in the case, as Your Honor knows, but it says that Ms. McGee formally revoked her Fifth Amendment objection to producing the cell phone for examination and invited plaintiffs to forensically examine her cell phone. I'm not real clear. I'm learning some of this in real time myself, Your Honor, but I'm not real clear on. I think, if I understand, that was in Ms. Gower's office. Understanding it sounds like it's the wrong phone, but that was there then. But I don't really understand, and I think Snap's prejudice, which is what I'm trying to talk about, goes to the fact that, I mean, what happened? Why didn't somebody look at it and figure this out in 2017, where it might be more likely, right, that you could solve that problem, meaning, oh, it's not this phone, it's that phone. And that I'm not clear on. All I know is that I don't believe Snap had any role in it. What Snap has said consistently is that she wasn't on Snap, and we know that because we looked at our metadata. And as Ms. Gower said, we provided an affidavit that said that. I don't think our position has wavered. We got the track phone data, which showed she wasn't using the phone. I think that is just like it's almost like a meter of whether or not you were using data, meaning making a phone call or doing anything else on your phone, and it has times that you are or not. Just like an easier example would be on our cell phone bills, it says, that a phone call came in from so-and-so number at 6 o'clock and it ended at 6:15, so the 15 minutes that the person was at the phone, that was on the phone. The same thing's true both in cell phone use, it'll, text, and then the data usage. Both of those things demonstrate that that she was not using the phone at the time, in addition to what she's testified to and the other witnesses. Without doing my full closing argument on that, I'll get to the point. The point is, as it relates to this data, right, I don't know what was on that phone and not on that phone, right? And I understand that being presented to the court and the prejudice the plaintiffs has suggested, but the absence of this data, it may or may not be relevant. And part of the plaintiff's burden, and part of our burden in showing this, to the extent that the ultimate goal, okay, because I just don't think anybody from that table will stand up right now and say that their goal isn't, they're not going to use this, or the purpose of what they're doing here isn't to try to make it more likely that she was using Snap at the time of the accident. There may be other goals, but I think that's what they really want to do. And what I wanted to tell the court about it, what I may want to ask Mr. Persinger about, just 2 or 3 questions, is this, and it's the Snapchat app. Okay, the whole reason my wife won't let me have it is because when you do something on it, it uploads to the server and then disappears. I don't remember the exact time period, but it's the whole it's like its thing, right? It disappears, right? And so the Snapchat app, the data goes away, right? And so, can I ask Mr. Persinger 2 questions?
Mr. Persinger, you can unmute yourself. You're still under oath.
Yes, sir.
Hey, Mr. Persinger, can you hear me?
I can hear you. Can you hear me?
Yes, sir.
Just remind him to be slow and loud.
Mr. Persinger, if you don't hear my question, let me know. When you give your answers, please be slow and clear and as loud as you can for the court reporter. Okay, sir?
Yes, sir.
Okay, thank you. You did a chip off of what I now understand to be the wrong phone. Is that true?
Yes, sir.
Okay, and was the effort to get the data that existed on that phone from the apps that were on that phone?
It would have included everything that phone contained within that memory chip.
Okay.
Not apps, but also any database usage, any cache file, any temporary file, it would collect it all.
All right, and one of the things that is in your report that that was referenced earlier by plaintiff's counsel was this long report you did, and it looks and breaks down the data that you pulled from that chip, right?
Yes, sir.
All right, and one of the apps that was on that phone, understanding that it may have been somebody different Snapchat account, was a Snapchat app, right?
Correct.
All right, and can you tell the court when trying to pull data from the Snapchat app, whether you were able to pull any data from her sister's Snapchat app when you did the chip off of the chip on the phone.
Yes, there was message data related to Snapchat.
Okay. Was there anything related to photographs or anything that you were able to pull from that?
It showed that there would have been photographs, but they were deleted.
Okay. Did it show? Does that mean, in your opinion, that somebody deleted those photographs from her sister's Snapchat account?
I can't say that somebody deliberately, because as you mentioned earlier, the idea behind Snapchat is to dissolve the message. Of variations of the versions of Snapchat would allow a user to specifically save some of that information, but that would be based on the version of the Snapchat that was utilized.
Okay, but is it true what I said earlier, that if the user doesn't save it, right, make some intentional act to keep it, that it disappears?
That's correct.
Okay, those are my questions. Thank you.
All right, thank you. Any more? Mr. Persinger, you may mute yourself. If the plaintiff has additional questions for you, they'll bring you back up. All right, Mr. Messon, you may continue.
I'm almost done. And so, understanding, I think that there is some question that will likely be answered as we make our way through the corporate representative deposition we talked about earlier, right? They've asked us to define some of these terms in the data. They're going to ask our witnesses more about this metadata and its reliability, and ultimately experts will form opinions, some of which you may have just got a preview to, about what would have been there and not been there as it relates to the Snap app. I'm not talking about anything else on the phone or anything else, but I want to leave you this, is that in terms of fashioning a remedy for this, which we have asked for as well, okay, because we believe that it does have prejudice to our client, especially when you look at the timeline. I would just say that that remedy is probably best fashioned with the benefit of the remainder of that testimony, because one of the things that is important is whether or not what would have been there or could have been pulled from there, right, actually answers a question that is relevant in the case. And so that's all I have to say at this point, other than no remedy, and I don't envy the court, but no remedy. The law that we've cited in our brief, I think, is pretty crystal clear on this point. Having had nothing to do with it and directed it, any remedy that is fashioned should not be to the detriment or prejudice of Snapchat. And I say that, I think I've said it in our brief, but I'll just say it again for the record. Thank you, Your Honor.
All right, thank you, Mr. Messon. All right, back over to the plaintiff's table. Floor is yours.
Thank you, Judge. I would point the court, and I'll pass out copies. We're talking about paragraph 26D as in David. And Mr. Persinger's first declaration, I'll actually just hand a copy to the court since I was too generous with my
Well,
copy.
I have it up.
Oh, you do?
Yes,
Sorry.
every time y'all reference a document, I've got it pulled up.
Okay. Paragraph 26D of his March 5, 2024 declaration. He states, cell phone devices typically provide a plethora of information, including but not limited to text messages, both deleted and undeleted, chat messages, both deleted and undeleted, phone calls, both deleted and undeleted, and that's repeated, so I won't keep saying it. Contact information, pictures, user account information, and a variety of device activity logs. Additional information typically found in a properly preserved cell phone includes data showing what apps were in use on the cell phone at or around the time of the incident. I think that is a little different than showing the content of a Snap message, which we understand is not typically permanent. But showing what app was in use is the heart of this case. So we think it is really, it's essential data that was on that phone. I would also make the point, we have been chastised a few times for not doing anything sooner with regard to preserving the phone. And if the court were to dust off the archives, you would see that on June 10, 2016, plaintiff filed our emergency motion to order the production, inspection, download, and preservation of Crystal McGee's cell phone And we stated time is of the essence. Ms. McGee objected on Fifth Amendment grounds. The council stated there's no evidence that she is failing to preserve it properly. And inexplicably, Snapchat filed a brief in opposition to our emergency motion. So that's why we were not able to inspect the phone when we wanted to, and here we find ourselves today. Finally, I don't disagree with Snap's contention that we're not trying to sanction Snap. And we're not trying to get I don't even know that legally any presumption, the court struck her answer completely. I don't have any reason to believe that we could use that against Snap, even if it's a line that pertains to usage. That's my impression. We haven't briefed it yet and researched it in any detail, but I think there is nothing in the law that says that the court is limited in its sanction of one defendant by theoretical implications on another defendant. There is a sanction, a proper sanction for spoliation, especially when it is something this crucial, and especially if the court as fact finder finds evidence to suggest that it was in bad faith. And I think in this case, that sanction is striking the answer, because there's no way around what was on that phone. We'll never get to see it. It could be in the bottom of a creek or a landfill somewhere. I don't know, but I don't think we ever will. And that's all I have at this time, Your Honor. Okay. Thank you.
All right, just to go back through, anything else, Scott?
No, Your Honor, other than just that we still have potentially more phones. We're still going through them. I don't know if there's anything on them. I don't think there will be, but we will continue that if you just instruct me.
I am instructing you to do that.
Thank you, Your
So
Honor.
I expect y'all to find every phone in that family and test it.
Yes,
So-
sir. And then, otherwise, as I said, it's a liability defense for us. I think the data can be found and it's out there, and you're well versed in it, and I trust you.
All right, thank you. All right, anything else, Mr. Masters, Mr. Boyle?
No, I don't think so, Your Honor. I think just to the extent that there's been a attempt to chip off that plaintiff and Snap split, if there's gonna be additional testing in that regard, I think maybe it might be fair that, the insolvency pool, pick up the tab on that.
That's already done in my mind.
Sorry,
So,
okay,
yeah.
I didn't
Sorry.
mean, I didn't mean
Tell your
to.
people, whatever testing comes next, you're responsible for it.
That's fine, Your Honor, and it's on the record, and if I need to order a copy, I will. That's fine, Your Honor. I understand.
I'd like to put on the record that Mr. Neff agrees with Mr. Masterson on that point.
There we go.
So-
I didn't see Mr. Adams put that Mr. Neff, but it still works, so there's,
I'll
it's an indirect agreement.
I'll take it, Your Honor. I'll
I'll take it. Okay.
We would only ask that Mr. Persinger be involved in any testing that takes place, which probably is foregone, but
Well, and obviously we'll very likely get to know Mr. Koger better as things go forward and he becomes part of this. And for record, we didn't end up hearing from him today, which is fine because I wasn't really wanting to get into that, but I understand that he'll become a name. It appears that he'll become a name that everybody will get to know, but y'all will cross that bridge together. Just make sure Mr. Persinger's in it.
Yes, sir.
So, okay. All right, so I'm gonna take these things under advisement. What else do so we've got the 30B6. We have a plan to get a plan.
yes.
We've got a roadmap on the CEO depot. We've heard, I'm just gonna call this phase 1 of the phone question, because
Yes, sir.
obviously y'all are looking, I'm so bad at pointing and saying y'all, and the transcript does not protect me there. Ms. Gower, you and your team are gonna scour their family for phones and test
Yes, sir.
all of them. We may end up hitting the jackpot and finding the phone. I'm not hopeful, but at least we know we want to be able to check all the boxes
Yes,
before I make a final decision on it. And so I'm just going to I'm not going to issuing any orders at this time on the spoliation until I can get that final answer. And we can deal with that a little closer to trial as we get to it.
Yes, sir, Your Honor.
I just want to make certain I don't want us to my fear is we get to the end of discovery and then y'all find the phone and then I've got to restart a bunch of processes.
Your Honor.
That's my nightmare.
I understand that completely, and we
Okay.
will move mountains to get a resolution here for you as soon as possible, or a statement that it's just gone,
Thank you.
and we won't change the position, Your Honor.
I appreciate that very much. And again, I just wanted your client here to see so that your client can hear me say that I don't know the value of this, but I know that it has got to be in six digits over the course of almost 10 years of litigation over this. Because, I went back and looked at all of Judge Essery's stuff about this phone, and it was one of the things that he briefed me on extensively when I came on. And here I am, about to get into my third term, and we're still talking about this phone. So, all right. Anything else from the plaintiff before we adjourn? Any other housekeeping? No. All right, Ms. Gower?
No, sir.
Anything from y'all?
No, Your Honor.
All right, thank you. Mr. Khan, as always, you have standing permission to report virtually on all non-jury hearings. I just want to say that out loud. I emailed you that, and now I'm just saying it out loud.
You did, Your Honor, and I greatly appreciate that.
Yes, so that works great. And I want to just thank all of you for coming down. Again, y'all all do a very good job. Every time I say this, I mean it. Zealously representing your clients. It is a pleasure having such high quality attorneys here on all of your, every time y'all come in. I know you don't get along, and I certainly don't expect y'all to go out for dinner and drinks afterwards, but I just want to say thank you for everything y'all do to advocate for your clients. My goal is to get this thing to a courtroom with everyone having what they need to try the case they need to try. And I appreciate your patience as I navigate my way through this, as it is both a very simple car wreck case, very serious but simple car wreck case, and a very difficult and frankly new territory technology case. So, and I appreciate y'all's patience as I try to balance those things. So thank you all. All right, if nobody needs anything else, I'm going to say adjourned, and y'all have safe drive back. Good news is you're going against traffic going home.
Thank you, Judge.
Thank you, Honor. It's
Thanks,
good
y'all.
to see you.
Thank you. That's good stuff.